Hello, everyone. Welcome to the webinar. My name is Sarah, and I'm going to be acting as a host today. Today, we are going to be talking about post-decree relocation, and we are so lucky to have attorney Yasmin here with us. She is going to kind of walk through this process, answer some of your questions, and hit on some of the topics that are most relevant to post-decree relocation. As always, your questions, participation, registration are all anonymous. So please feel free to type any questions that you have in the chat box in the bottom of your screen. And I will read out your questions at the end of the webinar so Yasmin can answer them for you. Thank you everyone for registering. Thank you everyone for attending. We are so excited. So I'm going to go ahead and have Yasmin get us started.
Thank you, Sarah. Hi, everyone. As Sarah said, I'm Yasaman, and today I'm going to talk about post-decree relocation. Again, specifically, we're talking about state of Colorado. So we're talking about the post-decree relocation matter and what the law is in Colorado. So first, before I jump into more details, I'm going to tell everyone what I mean by post-decree, which some people might be confused about the title. So when we're talking about post-decree, we're talking about cases in which the court has already issued an order regarding parental responsibilities concerning the minor children. And after the court has issued the order, either within few months or within years, no matter the time frame, one of the parents wants to relocate to out of state or somewhere else with the minor children. So that's the focus of this presentation today. Before we move forward with more details, I want to make sure everyone note that this presentation is not a legal advice and it does not create an attorney-client relationship. So please, if you have any specific questions or you need representation, you can give us a call, give our firm a call, Johnson Law Group, and we can definitely help you. And if you would like to, we can retain our firm and we can represent you. As Sarah said, thank you so much for registering and thank you for attending and listening to this presentation. So I know that I briefly touched base on what I mean by post-decree relocations. Before we dive in, I'm going to talk about what's the difference of pre-decree relocation versus post-decree relocation. So we touched base about what I meant by post-decree relocation. Pre-decree relocation are the cases that there has not yet been an order issued by the court regarding allocation of parental responsibilities, meaning parenting time, decision making for the children, and one of the parents want to move out of state or somewhere really far from the other parent within the state. So in these cases, usually happens when one of the parents have filed for either for divorce or allocation of parental responsibilities. And once that case is pending, they say that they intend to relocate with the minor child. So there is a different legal standard that applies to pre-decree relocations versus post-decree relocations. So for pre-decree relocations, when there's no court order yet regarding allocation of parental responsibilities for the children, the court has to apply the best interest factors set forth in Colorado Revised Statute Section 14-10-124 Section 1.5a. So I'm not going to get really into the details as far as what those standards are, because we are mainly talking about post-decree relocations in this presentation. But briefly, the best interest factors are the same factors that the court have to apply when one of the parents ask for allocation of parental responsibilities, even if there's no issue of relocation. So they usually are what are the wishes of the parents as far as allocation of parental responsibilities, if the child is mature enough to be able to basically discuss his or her wish as far as parenting time with the parents, what has been the past history of involvement of the of the parents with the children, which one was more involved, which one's the primary parent, if they were equally responsible for the care of the child, and the adjustment of the child to one parent's home, or they're equally adjusted to both parents' homes. So there are like numerous factors. I'm not going to go through all of them one by one, but I want to make sure that everyone knows that the court would apply different standards if there's a pre-decree relocation as opposed to post-decree relocation. So for post-decree relocation, there are specific factors set by the statute in Colorado Revised Statute Section 1410-10-129 Section C. In that statute, the law specifically provides what are the factors the court needs to address when one parent wants to relocate with a minor child after the court has already issued an order concerning allocation of parental responsibilities. We will get into those factors and we talk about them one by one later in the next slides. So one of the questions that some of our clients ask is when the other parent ask for relocation, what are their options? What can they do when the other parent asks for relocation with the minor child? Basically, there are two options. One option is the parent who's going to remain in the state, or who is the minority parent, can fully contest the request for relocation by the other parent and request that he or she will be the primary parent, so the child would stay with that parent in the state of Colorado. So that's one option, which happens a lot. Sometimes parents don't want their child to move to another state, move somewhere else, and they fully contest that, and they say that I'm willing and I have the ability to become the primary parent, so my child can stay in the state of Colorado. The other option is the parent who wants to remain in Colorado don't really object. He or she doesn't really object to the other parent relocating to another state with the minor child. However, they are not in agreement with what the other parent proposes as far as modified parenting plan. What I mean by that is, of course, when two parents are in the same state, it's easier to have more frequent parenting time for both parties with the child, because they're, as far as proximity, they're much closer to each other. But when one of them wants to move, especially if they want to move to another state, somewhere far from Colorado, it's really difficult to have that frequent parenting time with both parents, and specifically when the kids are at school age. They have to go to school during the year, and it's kind of not possible for them to travel back and forth frequently. They cannot, of course, travel every week. It's not really in their best interest to travel every month. So that parenting plan that the parties had in place when they both were in Colorado has to change. Usually what happens is one of the parents would be the parents that want to relocate with a child, and if the other parent does not object to that, that parent would be the primary parent during the child's school time, like during the year, and the other parent who remains in Colorado and has no objection to relocation would exercise parenting time in summer, during holidays, during school breaks. So parents have to modify that parenting plan. In that situation, a parent who wants to remain in Colorado has no objection to relocation might say that, like what you're offering as far as a modified parenting plan, I do not agree with that. You're like limiting my parenting time a lot. I can have our child during majority of summer holiday. So in that situation, the parent can say that, yes, I do not object to relocation, but I'm not in agreement with the other parent is proposing as far as modified parenting plan. In that case, the court will still address that. Although there's no objection to the relocation, the court understands that that parenting plan that's currently in place needs to be modified, and the court will address that, and the court will have hearing regarding that if the parties cannot reach an agreement on their own or during mediation. So I'm going to briefly talk about what the statute says regarding relocation. So as we said, the statute that governs the issue of relocation is Colorado Revised Statute Section 14-10-129, Section 2C. The statute says that the party with whom the child resides the majority of time is intending to relocate with the child to a residence that substantially changes the geographical ties between the child and the party can ask for relocation. And what that means, substantially change the geographical ties. So sometimes our clients call us and say, hey, the other parent who wants to move, it's not to move out of state. It's they're going to move within Colorado, but to a different city. Is that a relocation? Do they need to file a motion to relocate? Or the parent who wants to relocate asks us that question. And the answer is depends. How far are you going to move? Like, is it, are you guys exercising 50-50 parenting time? If that's the case, if you're moving, let's say somewhere that is 6 hours drive one way to Denver and the other parent lives in Denver, of course, that you guys can no longer exercise that 50-50 parenting time. So your move to a city in Colorado, which is 6 hours away from Denver, or better to say that 12 hours round trip to Denver, that substantially changes that geographical ties between the child and the other parent, and the other parent no longer can exercise that 50-50 parenting time. So it's going to be basically prevent that parent to exercise the parenting time that was allocated to him or her as the parent who wants to remain in the same location. So yes, in that situation, there need to be a relocation issue. But if you're moving somewhere that, let's say, just 1 hour away from your old place, that's not really relocation. Most of the times, parents are able to figure out a way that they can still exercise their previous parenting time. If like they just like add the parents relocation to somewhere like 1 hour away, just add 1 hour to the drive. So that's not really a relocation. So it really depends on where that parent wants to move. So yeah, the question is yes, even if you decide to move somewhere far away in Colorado, then that can be considered relocation. And of course, moving out of state to another state is considered relocation, because that kind of caused that proximity issue that the parents are not going to live in the same state and they're not close enough to be able to exercise the same parenting time. And of course, you're leaving the state, so you need the permission from the court to leave the state of Colorado with your child. And the rest of the statute basically address that the time frame for when the court would address the issue of relocation if one of the parents requests the relocation. So usually the courts understand that this issue kind of urgent, because most of the times when one parent asks for relocation, they already had the plan. They already know like when they're going to move, when they're going to move, if they're going to change the child's school. So that's kind of a priority for everyone, and the courts understand that. And because of that, the statute says the court shall given a priority on the court's docket. So when motion for relocate is filed with the court, usually the court understands that, as I said, is a priority issue. So they try to schedule a hearing as soon as practical. That doesn't mean that they will schedule a hearing within a few weeks, but usually the court system is relatively slow depending on how busy they are, how busy their dockets are, but usually take a few months to schedule a hearing. But for relocation hearings, they try to schedule those kind of hearings sooner rather than later, because they understand that's kind of an urgent issue that need to be addressed by the court if the parents cannot reach an agreement. So we briefly talk about what the court would consider as factors for relocation if one parent asks for relocation. So we are going to go through those factors one by one right now. One of the factors are the reason why the party wishes to relocate with the child. So the parent who wants to relocate has to provide why they want to relocate, and that can be different issues. They got a job in another state, they got remarried, and their new spouse is moving to that new state because of their job, some other situation, so they have to move. If they don't have any family in Colorado, but they have family and that's the support system in another state, that's why they're trying to move there. Second, the reason why the opposing party, which means the other parent who wants to remain in Colorado, objecting to the proposed relocation. And so that parent has to provide the reasons. For instance, if someone comes and say that I want to move to Arizona because I got a job there, the opposing parent can say that, okay, like he or she, the other parent, has not provided reason why they cannot find the same job in Colorado. So usually what we do in those situations when we are representing the parent who's opposing the relocation, we ask the parent who requests a relocation provide information how many jobs they have applied for in Colorado, where they're able to find similar jobs with similar pay in Colorado. If not, why? So basically, it's kind of like a battle between two parties to basically prove that the parent who opposes it has to prove that no, the parent who's requesting the relocation doesn't have good reasons. Because if it's because of a job, they can find same job in Colorado. It's because of their living situation. They can have a really good living situation in Colorado. And the parent who requests a relocation, on the other hand, is going to argue that no, the cost of living is lower in other states. With the income that I have, it's really difficult for me to afford paying for the rent and living expenses in Colorado because Colorado is expensive. So as you all know, some states are the cost of living is less than other states. So that would be that requesting parents' argument. So basically, they have to each provide the reasons why they want a relocation and why the other parent opposed the relocation. The other factor is the history and quality of each parent's relationship with the child since the previous parenting time order was issued. So basically, the court will look into who was more involved with the kid, who enrolled the kid in school, who was taking the child to his or her doctor appointments, who was making the appointments. Was that kind of equally shared between the parties, or no, one parent was involved because they were the primary parent or they had more time? Usually what happens that even not usually, but it's common that even if one parent is the primary parent, the parties have joint decision making, so they're jointly involved in those kind of activities for the child. But sometimes we see that even though the parties have joint decision making, still one of them is more involved in like not just making decisions but taking actions regarding those decisions, like enrollment in the school. both picked the school, but one parent did the enrollment, one parent did the research about the school, one parent basically scheduling all the appointments, taking the child to the doctor appointments, and basically the relationship between the child and the parent. Sometimes we see that child is more bonded with one parent as opposed to the other parent. So the court will look into those factors as well to see if the relocating parent is the parent that has more bond with the child, has been more involved in the child's life, and if that's why it would be better for the child to relocate with that parent. So before we move on to the other factors, I want to make sure that it's clear that the court cannot force the parent to stay in one state or relocate. So the court has no authority whatsoever over the parents to tell them that you have to stay in Colorado or you have to move out of state. But what the court has jurisdiction over, authority over, to make a decision if the child has to go with that relocating parent. So basically, the parent who wants to relocate has to provide information and argument not only about why he or she wants to relocate, what are the reasons, have to provide information and arguments why it's in the best interest of the child to go with them. Otherwise, just providing information as why as a parent you have to relocate, that wouldn't be really enough for the court to consider. The next factor is the educational opportunities for the child at the existing location and at the proposed new location. So basically what happens is the parents provide information that, okay, the child is going to school here in Colorado. This is the school's ranking. These are the classes that the child attends at the school that they need, and they compare it to that other school where the relocating parents wants to move. So we use this time say that the parent wants to move to California. So basically, the relocating parent and the parent who opposes the relocating should provide information to the court about that. Sometimes we see that parents find some really helpful information about schools as far as how they compare them, especially when the child has needs for some specific classes, or let's say that it happens that the child is behind in reading, writing, math, any of those subjects, and the parent can provide information to the court that the school that the child is going in Colorado is able to provide the resources that child needs to be able to improve his reading, writing, math, science, and any subject. But that school in California does not have the resources, or the parent who wants to relocate has not provided any information that that school is able to provide the same resources for our child. Or vice versa, the parent who wants to move to California can say that I didn't research the school ranking in California is better. I already picked the school where I want to enroll the child. This is the school rankings for that specific school in California, and this is the school ranking in Colorado. Or like the school that my child goes to in Colorado is requires lots of driving. The school in California would be really close to where we live. So basically, the more information the parties can provide to the court, it would be more helpful and more guiding for the court to basically be able to basically make more informative order and decision at the end. The other factor the court will look into is presence or absence of extended family at the existing location and at the proposed new location. We kind of I mentioned that in the previous slides that one of the reasons that the relocating parent can refer to is I don't have any extended family in Colorado. I don't have the support system. But if I move to California, I have my parents, I have my siblings, I have lots of extended family who can provide a support system for me and the child, basically. I don't have that family member in Colorado. Or vice versa, the opposing party who opposes the relocation can say that my child does not have any extended family in California. All the family, even the relocating parents' family, extended family, are in Colorado. Everyone is in Colorado. So if they move to California, they don't even have anyone. They don't have the support system. That kind of prevents my child from seeing his extended family who they have a really close relationship. Like, let's say the grandparents, maybe they have cousins that are around the same age. So that's the court will consider that as a factor as well, because they see it as an important factor for us having a support system as far as extended family, or having that kind of relationship with the extended family members are important. The other factor is any advantage of the child remaining with the primary caregiver. So that can include anything, any advantages that the primary caregiver, who's the relocating party, can address. Basically, again, that goes back to a bit of relationship of the child with parents. As I said, sometimes the child is more bonded with one parent for any reason. Maybe it's because they spend more time with that parent, maybe because that parent was their primary caregiver since they were born. The fact that that parent has been more involved in making decisions for the kid and taking action upon those decisions. So what are the advantages of the child staying with that primary caregiver who wants to relocate? Or if the primary caregiver who wants to relocate has more time to spend with the child because they work less hours, or the parent who wants to remain in Colorado has longer work hours. Let's say they sometimes work on weekends. They have after they work after hours. Like they don't just get up at 5. They work like till 8. Like some days, some weeks, as I said, they work on weekends. But the primary caregiver who wants to relocate has more time to spend with the child. So there can be any reason that the primary caregiver can provide to the court. The other factor is the anticipated impact of the move on the child, and that means that is that going to be a big change in the child's life? Which is the answer is always yes. Relocating to another state would be a big change for the child, but what's the impact? You see, the child, he or she, going to lose lots of his or her friends because they have to change the school. As we said, like, do they even have any extended family in the relocating state? If not, so they're going to kind of lose that kind of relationship they had with their extended family. They are still going to be able to see the extended family, but the duration and frequency would be much limited. So that's not a desirable impact depending on how close that relationship is. Changing school, would that have any adverse impact on the child? So basically, the court will look at all those details, and again, the more information the parents will provide to the court, it would be easier for the court to make informative decision as well as what would be the impacts. Are there adverse impacts? Are there positive impacts? What will happen to the child? Or some children are fine. Like there were no negative impacts on the child from moving. And again, we are talking about something that might happen in the future, and the court understand that, but the court understand that the parties know their child really good, and they know their living situation really good, and they know their circumstances really good. So based on that, they can provide that information to the court. The other factor is whether the court will be able to fashion a reasonable parenting time schedule if the change requested is permitted. So that really depends on where the relocating parent wants to move. Most of the cases are relocation within US, so it's within the country and different states. And in those situations, most of the time the answer is yes. We've seen that the court is able to provide a parenting time and schedule, like a reasonable one. As I said, usually what happens is the parent who's the relocating parent, if the court orders that the child can relocate with that parent would be the majority time parent during school year, and the other parent who remains in the state will have mostly summer, majority of summer holidays. Sometimes they alternate holidays, but some holidays would be allocated to the parents who remain in state. Or the school breaks, like some schools have fall break, all schools have spring break. Some usually the parent who stays get those, and sometimes depending on the kids age, sometimes they they order that the kid would travel back to Colorado like every few months to exercise more parenting time with the remaining parent, or the parent can travel to the other state to exercise more parenting time. But if the parent is relocating to another country, so that makes it a bit more difficult. First, mostly what my clients ask me is that would that make a difference if the other parent wants to move to another country? Are the courts are going to consider the same factors that we kind of went through if the other parent wants to move to another country? The answer is um, yes, the court will address the same factors regardless if you're moving within the country or you're moving abroad to another country. The factors are the same factors that we went through, and we're still continuing to address one by one. But the issue of how to modify the parenting time would definitely change, because um, basically when one parent wants to move out of country, then that would be more traveling time. I mean, it depends on what country they're moving, how far is the flight, what are the like, can the remaining parent travel to that country to exercise more parenting time with the child, or not? Can the child easily travel back to United States, to Colorado, to see the parent? Depending on the child's age, if they can travel alone, is there anyone to travel with them? So kind of add more issues to if the court can fashion a reasonable parenting time based on the change that's requested. And that doesn't mean that the course cannot end up with reasonable modified parenting time if one parent wants to relocate out of country. We have had cases where one parent wanted to move out of country, and the court was able to basically provide a reasonable parenting time based on the location the parent and the child were moving, and basically how the other parent can still have reasonable amount of parenting time with that child. The last factor is any other relevant factors bearing on the best interest of the child, which kind of mentioned that, like, that kind of goes to other factors as well. You're not just restricted to all these factors listed by the statute. You can provide more helpful information to the court as far as why relocation is in the best interest of the child, or on the other hand, why relocation is not in the best interest of the child. It's better for the child to remain in the state of Colorado. So basically, you can provide any information that you believe that would be helpful for the court. Of course, your attorney can help you to determine if there is specific information that would be crucial and helpful to provide to the court or not. That would be basically part of process, the discussion you would have with your attorney. So we kind of address the factors for relocation, what the court will look into, what you need to provide to the court. What we didn't address is how to start a process if you're the parent who wants to relocate. If you're the parent who wants to relocate with the child, the first thing you need to do is, of course, you have to communicate with the other parent. Tell them that you intend to to relocate out of state. And the most important step is to file a motion to relocate with the court as soon as possible. And the reason why I say as soon as possible, because I understand that, as I mentioned before, relocation matters are kind of urgent. Most of the times, people don't decide that they're going to relocate in 2 years. It happens. Sometimes it happens. People decide to relocate in a year or 2 years, but most of the times, they start planning for something, and then when they get the confirmation that yes, like let's say they got an offer they got an offer for a job, or they have found a living place, then they really decide they have set plan to relocate, and they want that to be addressed within few months. So that's why I recommend that if you decide to relocate with your child, file a motion for relocation with the court as soon as possible, because although the court is required to address that as an expedited matter, but still takes a while. Still, sometimes the courts require parties to go to mediation before going to the hearing. Sometimes it would take a while for the court to set the hearing. Not that they don't want to; it's just the courts are really busy. They have like thousands of cases, and sometimes they don't have the availability to set the hearing as soon as possible. So the sooner you take to file a motion with the court, the sooner the court can address it. I don't recommend wait till last minute. Like if you're planning to move next month, filing a motion to relocate a month before, not a great idea, because usually the courts are not that fast unless the other party agree that you can relocate with the child. That's a different issue. You can file an agreement with the court, and the court would adopt that as an order of the court. Otherwise, I do not recommend waiting till last minute, because the courts are not that fast, and then you cannot move until the court issues an order or the other parent agrees. So you cannot just file a motion and move out of state. I have to wait for that, and that takes a while. And as I mentioned, you cannot relocate with the child without the court's permission or the agreement of the other parent. So you cannot, as I said, you cannot move them, file a motion to relocate, and just relocate. You have to wait for the process to be done, and you get the court order regarding that. What happens if you or the other parent decides to move out of state without the court's permission or agreement of the other parent? I do not recommend doing that at all, and I will tell you why. So, if you relocate with the child and take your child, just move to another state without getting the other parent's agreement, and by agreement, I mean written agreement that's filed with the court, not just saying yes, that's fine. Because sometimes people change their mind, and there's no guarantee that other parent doesn't change their mind unless there's something written, signed by other parent that yes, I will agree with you relocating with the child out of state. So unless you have that written agreement from the other parent that's filed with the court, you cannot relocate out of state without the court's permission. If you do, the other parent, of course, the court would not notice it because the court does not keep track of everyone, but the other parent will notice that you moved out of state. And what they can do, they can file a motion for contempt of the court order, because basically you have violated the court order by taking the child out of state that interferes with the other parent's parenting time. And in that situation, the court would schedule a hearing. The court order you to return the child to Colorado, and the court has authority to impose sanctions on you. And sanction means the court can order you to pay for the attorney fees of the other parent. The court can restrict your parenting time for a while because you violated the court order. So there are different sanctions that the court can impose on you, and the court would kind of draw a negative inference on a parent who decided to just take the child out of state without asking for the court permission or the other parent's agreement. So that's not recommended at all. It's better to plan ahead of time and file a motion and wait for the process to be done, so you can just know that you're not violating any court order, there is no issues, and then you can just easily move out of state with the child. And if you have done that, if for some reason you didn't know that you cannot relocate out of state with your child without the court's permission or the parents' agreement, and the court orders you to return the child to Colorado, do that as soon as possible. Because if you don't do that, the court has the authority to contact the police, basically the enforcement in the state that you're currently in, and then ask the police to come and get your child and return the child to Colorado, which is not desirable. No parent wants that to happen. No parents want the police to show up at their house and take the child from them and return them to Colorado. So make sure you're following the court order. That just makes the whole process easier, and you don't have to be worried about what happened to my kid, what do I need to do now, and then you have to the court will not impose sanctions on you. So it's really important that you follow the procedure as far as what you need to do, as far as filing a motion to relocate and going through the process before you relocate with the child out of state. So that was briefly about the post-decree relocation, as far as what you need to do to start the case, what factors the court will look into, and what information you need to provide to the court. We mainly talked about post-decree relocations today. I briefly mentioned what's the difference between pre-decree relocations and post-decree relocations, but we mainly focus on post-decree relocations at this presentation. Thank you so much for registering for the webinar and attending the webinar. And I think now it's time for any questions anyone has.
Thank you so much, Yasmin. As she mentioned, if anyone has any questions, now would be the time to ask them. You can just type them into the Q&A box or the chat box on your screen, and I will read them out to Yasmin. As always, thank you so much for attending. Thank you so much for registering. If you think of any questions after the webinar, please feel free to email us at info@johnsonlgroup.com, or you can feel free to give us a call. We can put you in contact with Yasmin or any of our other expert attorneys that would be more than happy to help you with your cause. Also, we have a few more upcoming webinars, so feel free to follow us on social media, Facebook, Instagram, LinkedIn, and YouTube. Speaking of YouTube, you'll actually be able to access this webinar and all of our past webinars by following our YouTube account, which you will get in an email after this webinar. I'm not seeing any questions, but like I said, if you do have any questions, if you think of them after this, please reach out. We are more than happy to help you with any problems that you may have. We do also offer free consultations. So if you do need a consultation with your matter, please give us a call and we will happily walk you through that. Thank you, Yasmin, for taking time out of your day to speak with all of us. This was incredibly helpful, and I hope to see everyone at the next webinar. Thank you.
Thank you, Sarah.